Thank you, Wendy. Good evening. Today is Tuesday, April 2nd, 2024. Thank you for joining our virtual town hall meeting this evening. I am Eduardo Mundo, Chair of the Probation Oversight Commission. The purpose of tonight's meeting is to inform the public and our partners about the stages of detention in the County of Los Angeles and how the Welfare and Institution Code defines, approaches detention. I will introduce the panelists, then POC Director Wendy Julian will share some ground rules for participants, and then we will proceed with the presentation, a discussion with our panelists, and conclude with comments and questions from the public. Thank you, esteemed panelists, for joining us today and for all of your work with youth in the justice system. We appreciate your willingness to talk about this. Joining us tonight, we have my colleague, Diane Terry, POC Commissioner at Large, Erin Palacios, attorney with the Youth Law Center, Director Norberto Zaragoza, Los Angeles County Probation Department, Shalon Joseph, Los Angeles County District Attorney's Office, Luis Rodriguez, Los Angeles County Public Defender's Office, Eric Rodstrom, Los Angeles County Independent Defense Counsel's Office, Samuel Abrahamian, Los Angeles County Alternate Public Defender's Office, and myself, Chair of the Probation Oversight Commission and a retired supervising deputy probation officer, a 30-year career which included many years working intake, the stage in the process where probation is most involved in decisions that impact detention numbers. Wendy, please explain how people can participate in tonight's virtual town hall meeting.
Thank you, Chair Mundo. I'm very excited about tonight's town hall and very thankful to the panelists who are joining us and everyone who's here in the audience. The Probation Oversight Commission takes public engagement very seriously, and we really want you to participate today. Please know we're recording this broadcast. We're also broadcasting it on YouTube Live. You can listen to it there, but if you want to give public comment, you have to be here on WebEx. So if you're on YouTube and want to give public comment, please go to our website and log in to the WebEx so that we can listen to your comment. That's poc.lacounty.gov, and it's under the tab Meetings. Tonight's town hall is not governed by the Brown Act. We don't have a quorum of commissioners here, just Commissioners Mundo and Terry, and we won't be taking any action today. We do want you to participate, though, and we'll leave plenty of time for comments. You can also send us an email at info@poc.lacounty.gov. We will put that in the chat for you. After we hear the presentation from Chair Mundo, the panelists will be answering some questions, and then depending on how many people from the public want to comment, we may limit each commenter to 2 minutes, but unlike in the public meetings, I am not going to be cutting you off for fairness purposes. Chair Mundo will be cutting you off if you go far beyond the 2 minutes. And if you have a question instead of a public comment, you're welcome to ask that question directly to one of the panelists or to multiple panelists, and they can answer the question in more of a conversational format. In order to give a public comment after the presentations, please use the little raise your hand function. It's a tiny hand at the bottom of your screen. You just tap on it and it will add you to the queue. We'll unmute you and then you'll have to unmute yourself, and you can let us know if it's for a specific panelist. Also, if you're calling in, you need to dial *3 on your phone, and that will raise your hand for us, and we'll call you by your phone number. Buenas tardes, una cordial bienvenido a la conferencia por WebEx. También si nos está viendo por YouTube. Si quiere participar, tiene que estar en la conferencia por WebEx. Puede encontrar el link para estar con nosotros en la página de web. Si quiere hacer una pregunta o hacer un comentario público, por favor haga clic en la imagen de la mano y le llamaremos cuando sea su turno. Si está escuchando por teléfono, quiere hacer una pregunta, presione *3, eso levanta su mano y le llamaremos por su teléfono. Si necesita traducción, puede pedirlo y yo se lo traduzco, o también usted puede proveer su propio traductor y le daremos el doble del tiempo para la traducción. We ask everyone to please abide by the following communication guidelines during today's meetings. We ask that you introduce yourself with your name, share your thoughts, be respectful of time so as many people can speak as possible. Remain respectful to everyone in the room. Honor equity and participation, and practice grace and openness. And please use I statements, speak your own truth. And with that, I will turn it back over to you, Chair Mundo.
Thank you. To kick off our conversation, I will give a brief presentation on the stages of the Welfare Institution Codes that cover not just the sum of detention philosophy, but also the tone of the way we should think about detention of youth. Slides. The process, so we don't spend too much time on the details, but when it really gets the process going, if it's a booking that requires probation to review the matter and the youth has to be taken before a judge, then the law enforcement agency will contact probation and clear the transportation of the youth. Once at probation will interview the youth, look at all the materials, and provide the court with the report and a recommendation. At that point, the attorneys in the courtroom with the judge review all the material that's available and make arguments. I am going to be really brief on that point because we have the attorneys that are in the courtrooms here, so I'll let them fill in the blanks. Once a decision is made by the bench officer, the youth remains detained or released, or in some cases detained, housed on probation, on the CDP, which is a form of house arrest. And after that, the case proceeds. So that's just in a nutshell. Next slide. So these slides I gathered were just to get people thinking. And in reviewing court findings, there are usually 4 or 5 court findings. And the ones that really pop out are the ones that are highlighted here. The court will find that the continuance in the home is contrary to the minor's welfare, that reasonable efforts have been made to prevent or eliminate the need for removal, and that there are no available services that would prevent the need for further detention. Those are highlighted because those findings in most cases are found within 48 to 72 hours, weekends not included. Next slide. So 625.3 mandates the youth to remain detained and cannot be released prior to a judge being involved in the case. Next. 203 is the one that I just find the most interesting because it basically says that the juvenile court is not a criminal proceeding. And again, I'll let my panelists elaborate on that, but for our purposes, it's just something to bear in mind as we continue our conversation. Next. So 202, and the highlighted part is the part that really strikes out at me. If removal of the minor is determined by the juvenile court to be necessary, reunification of the minor with his or her family shall be a primary objective. If you scroll up to the next slide, please. If you have a chance to read this, it really talks about how a youth should be treated and what services should be provided when they're detained. And it should replicate most basic services that the youth has at home. Next. 281. This is the one that provides the authority for probation to do a factual report and provide a recommendation at several stages of court proceedings in the juvenile system, including intake. Next. 636. This one I'm going to have Aaron, our panelist, give a very detailed explanation of it. So skip that for now. Next. Is that it, Wendy?
I believe so.
Okay, so I'm going to go ahead and pass this on to the panelists, and I'm going to do it in the order of the detention process. So I'm going to start with probation and Roberto Zaragoza, who, if you can, just explain the role of probation at this stage in the process, and if there are any thoughts you have about improving it or things that should be removed from the process.
Yes, sir. Thank you, and good afternoon. As Commissioner Mundo kind of demonstrated in the first slide, I mean, we're basically the first contact after law enforcement with the detention of the youth. Law enforcement will call IDC and notify IDC that that they have in custody a youth of a high level crime. At this time right now, usually the cases that we will take are 707Bs, cases with a firearm, and also our bench warrants. IDC will take an initial report from the law enforcement, and we'll go ahead and kind of recommend whether to go ahead and bring the youth in. If it's a low-level offense, IDC will also recommend to possibly cite the youth out. But ultimately, if the law enforcement chooses to bring the youth in, we will take them, and we will do our due diligence at the IDC intake, where either we would cite or possibly refer a kid over to CDP, PDP while getting ready for court. The same thing, paperwork, we go ahead and ask them to make sure that they bring the 6 documents, which would be the police report, probable cause, juvenile entrance form, medical clearance, also DOJ live screen, and also a booking document. At which time, once the youth is brought in, the youth is assigned to an IDC officer, which will go ahead and kind of bring in the kid to conduct an interview. A phone call will be given to the youth to notify his parents that he's in detention. A call will also be placed to the PD, at which time to the youth would be Mirandized. We will go ahead and interview the youth and try to obtain as much information as possible from the youth and also the parent. We conduct an investigation to ensure that we can go ahead and put together the most information in the detention report. At that time, then the detention report will be submitted to the DA, at which point the DA will determine whether to file a case or to reject the filing, and then it's moved over to the court, at which time the judge will go ahead and recommendation as to the outcome of the youth. Thank you.
Thank you, Mr. Zaragoza. Once probation completes that report, they submit it to the district attorney, who attaches it to the filing documents. So with that in mind, Shalon, if you can make a little presentation regarding your agency.
Yes, thank you so much for having our office represented here this evening for this town hall. We're happy to participate. And as Mr. Zaragoza indicated, after probation makes its determination about detention, the paperwork is then sent to our office for evaluation of whether or not charges should be filed. Once charges are filed, we do review, it's part of the process of filing charges. We also review the detention report, review probation's recommendation about whether detention should continue, and assess that with actually the factors that were presented on one of your slides, which is whether or not there are any prior cases before the court, whether or not there's a public safety issue with release, what, if any, harm was done to the victim in the case and how serious that harm is, and if there's a continued threat to the victim in the case. And we assess all of that in deciding whether or not we are going to support probation's recommendation to the court or go along a different path if the defense presents us something that indicates we should, be arguing for something that is not consistent with probation's recommendation. But for us, the detention question falls around public safety, continued harm to victims, and the nature of the charges. And as you indicated in your presentation, Chair Mundo, whether or not it is a 707B charge where detention is mandatory.
Okay, thank you, Shalon.
Thank you.
Just for the purpose of clarification, can you give some examples of 707Bs and maybe the range of elements that those can take?
Yes. So, the most serious 707Bs are obviously murder, attempted murder, and then going down, there are a few charges where they could, like 211, for example, which is robbery. Those have different variations, right? There are robberies which are very serious, which can be with a firearm or with physical threat or violence or even hurt. And then there are others where it's, someone grabbed a cell phone from someone's hand and then went out, which could technically fit the elements of a robbery because that item is taken by force. And the same thing with an assault, a 245. Those can be simple assaults, or they can also be assaults with a firearm, assaults where great bodily injury is inflicted. And then, so you have the most serious, murder charges, attempted murder charges, and then you have others that have kind of gradations of seriousness, which could still qualify as a 707B technically under the law if the elements are met.
Thank you. So Luis, you're the last one before the judge to see the report and see all the documentation, and your group takes it. So what next?
So let me go. Well, first of all, Chair Mundo, thank you for the invitation. Wendy, commissioners, thank you for this opportunity. Let me take it a step back because Mr. Zaragoza talked about something that I think is very important that just was implemented into law this year, which is we normally hear when anybody gets arrested that the police are supposed to advise him or her of their rights to remain silent, what is commonly known as Miranda. Well, thankfully, the state legislature found that with youth, they're obviously not as sophisticated as us adults. Sometimes they have learning disabilities, cognitive delays. So it has to be special care as to how they're treated. So a new law was passed at the beginning of the year, or enacted, I should say, that requires probation anytime that a youth is taken into their custody, whether it's for a new arrest or a bench warrant pickup. Then the public defender or the defender service of that county must be contacted within 2 hours of the youth coming into probation's detention. The reason I say that is because we know as adults, we're intimidated by the fact that sometimes we're driving down the street of the freeway, all of a sudden we see the red lights in our rear view mirror and we freeze, right? So for those folks, if you can only imagine a youth being physically arrested, put into handcuffs, and driven to a jail, just the trauma and the mentality that they're in. So some folks up in Sacramento thought it was important to provide some protection, and therefore now there's a requirement that the defender office must be contacted. And the reason being, in fact, today, as we speak, I'm on backup Miranda duty. So if you see me go off camera, it's because I'm getting a call from probation, which from the intake department. So that's what happens. That's the way it's supposed to happen, because we want to advise the youth, the child, what to say or not to say. From that point, obviously, as it's been explained by Mr. Zaragoza, Ms. Joseph, the process begins and moves forward. We, the public defenders or the attorneys assigned by the court, the first time that we see the youth, we may have talked to this youth during that 2-hour period before the arraignment, is what is called the arraignment. That's where the court appoints us, and every public defender is an attorney. Let me make that very clear. Sometimes there's confusion whether public defenders are real attorneys or not. We are real attorneys. And that is our sole role. We do not get paid to do our job by the family or the youth. We get paid by the county. So it's a free charge to anyone, any youth coming in through the system. And our role is obviously to review what the charges are. We advise the youth as to what his or her rights are. And then depending on the offense, we will advocate with the court to release the youth. So a lot of times the initial disagreement, and that's for various reasons. Prosecution has their interest in protecting public safety, the public. Our interest is releasing the youth into a less traumatic environment. So we're in there at the arraignment arguing for the release of the youth. From that point forward, the case moves into whether it's going to be set for trial, or we're in agreement with the prosecution that maybe there should be some kind of settlement offer in this case to get the youth out. But always our main goal is to fight for the youth, to get him or her release, or to get him or her the best possible disposition or settlement to get the youth either home or into an environment where they're protected. So that is what we do, and we continue the spectrum. But Chair Mundo, you asked what would we change if we could in the system. There's some, I think it's in the state of Washington. What I would change is that take people away from calling 911 for every single encounter with a youth that is problematic, and instead of having a different kind of system, a different type of impact team that comes out and assesses the situation, having either a social worker, a mental health professional, someone who can deal and de-escalate the situation, because not every look, the reality is police officers, law enforcement are not trained to be mental health service providers. That is the reality. So we need a different kind of system where these impact teams go out, assess the situation. If it's a situation where the youth needs to be removed from home, have a different alternative to incarceration, having a home that is provided by the county where the youth can be protected from him or herself or the environment. That's what I would change. The initial point of impact between the youth and what he or she is accused of doing, and then taking it a step further, whether the youth needs to be incarcerated or not. So I'll stop talking because I'm sure there's other folks who need to share more information. But that, in a nutshell, Chair Mundo, is where we get involved.
Thank you, Eric. I'm gonna ask you to explain to our attendees who may be hearing this and wondering, how is this not like the criminal court?
Sure. So differences. So and thank you for having IDCO participate as well, and thank you to everyone too for being here. How it's different. Number one, and most dangerous for the youth who are impacted by the juvenile justice system, there's no jury. So things are different, and this becomes a system where one person is deciding as the decider of fact, where in the adult system, there would be a jury deciding at trial. And I think that's fundamentally the biggest difference. I had been thinking about changes that I would ask for. And so you pulled me out of my thought pattern. But I think that's fundamentally the biggest thing. This is meant to be a civil system that is focused on helping a youth who may be struggling to get back on track, and rather than being a sort of punishment and incarceration system. And that is actually, originally the sort of well-intentioned reason why there isn't a jury trial. This is intended to be a collaborative system involving the judge, involving the prosecutor, involving the defense attorney and the youth and the family and building something. And I think over the years, for many reasons, that's obviously not the result that we see in real practice. But fundamentally, the goal of the juvenile justice system really is different, at least on paper and in its origins. And you see that, now in the real world, no jury trial, which changes the calculations of the attorneys and the youth when they're making a decision whether to go forward and fight the charges against them.
And changes?
So this is a weird one because we are living in a time with the Youth Justice Reimagined sort of progress where there are changes happening, and I really hope those changes continue happening. And so rather than seeing something to take apart, I see progress. And I think, when Ms. Joseph from the DA's office speaks, I think something huge, that I don't know. I think it's maybe the biggest potential change in detention in LA County, something to affect that in years, is a pilot they have that is going to look at the point of arrest, whether charges are filed, what types of charges are filed, and whether at that early decision-making point, detention is going to be sought. That is huge. So, if I were thinking of something in, say, my last 5 years working with the juvenile conflict panels in Los Angeles County, that may be one of the biggest things that LA County as a body has come up with. And I think it could have a huge impact.
Great, thank you. Sam, can I throw a question at you, or do you want to give change thoughts first?
No, absolutely. A question, and my apologies for not having a video on, but I'll take a question, of course. I think my colleagues hit all my thoughts on the spot, but please.
Okay, so the court findings, and you're in the courtroom. I haven't been in the courtroom in a while. Is it really possible to come to those findings on within 48 hours and with a single probation report?
Wow. The timeline, I think, is absolutely 48 hours. It's a tough question. It depends on who you ask. Obviously, I think if you ask us on the defense side, we might have a different opinion than others that are involved. I want to be quicker in the process, and I mean that in a way of not dragging on. I think that's a big concern. We have some kids who remain in a locked facility for way too long because of how quickly, or the lack of that we get to things. So the quicker would be better, but it depends. Sorry, I know that's not a direct answer to give as far as is 48 hours enough. It depends, but I would want things to be done quicker. Quicker, though, I mean that to the benefit of the minor, obviously. Absolutely for the benefit of the minor. So not to rush the judgment and just to get things moving along, but quicker so that we can get this minor on the right track quicker than later.
Any other thoughts?
And then again, I want to reiterate what my colleagues said, and they've heard me on my little soapbox many times. So thank God they don't have to see my face and hear me say the same things again, which is in this process, this collaboration that I hope that we're going to continue to try to meet and reach, the mindset of every party that's involved has to be the same. I think without that change, we're going to continue seeing difficulties. So many people I see us getting closer to that goal, but we need to be on the same page as far as who we're dealing with, meaning our minors, what the goal is. And I understand the prosecution's job, probation's job. I'm not saying don't do it, but if we can get on the same page, looking towards that same goal and outcome that we're looking for, that's how change is going to be made.
Thank you. Commissioner Terry, before I go to Erin Palacios, do you have any questions for the panelists that have spoken or thoughts?
I do have two questions. One is just to clarify, and then one is just a general question. I was curious to know at what point the family or social worker is notified. And I think you all said that, so it's after detention. Is that correct? I can't remember who said that. That's when the parent or social worker is notified in the process? Okay, I see shaking heads. Okay, thank you for clarifying that. I think another question I had was related to one of the earlier slides that was up. It talked about a determination being made, and some of the factors had to do with if there were no available services in the community to help that youth, and then also concerns about the minor's welfare in the home. So I'm just curious, how is that determined about the services and then the safety in the home? And is that within that 48-hour period?
I don't know if Mr. Z wants to jump in here, but I have some thoughts on that, which also goes to my failure to answer the chair's second part of the question, which is what I'd like to see improved. Because I think you're right, Commissioner Terry, that those determinations are made initially during that 48-hour time frame. And what I think LA County can strive to do better is have more options for young people who may not necessarily need to be detained, like in a domestic violence or familial situation. There are other counties that have cool down beds where those young people are not detained. They're put into alternate facilities where treatment starts right away, addressing whatever trauma the young person has suffered, as well as, starting family counseling right away, which we know through, every study that addressing those harms are provide the best outcomes for the young person. And also just finding more alternatives to detention, available alternatives, or what all of the people in the juvenile system consider viable alternatives to detention. Because I think right now we're limited in our view and perspective on what's considered, viable alternatives to detention in LA County. And one of the things that we've been doing actually all together, the defense and some of the juvenile court judges, is visiting placements outside of detention to see if we can agree upon, alternatives, like places that do offer all of the services that we think young people can benefit from. But as I sit in the kind of collaborative, least restrictive meetings that we have for detention, oftentimes we're struggling with dual youth who are part of the juvenile system and the DCFS system, who at the end of the day, everybody's in agreement that this young person shouldn't be detained. Everybody on the screen is in agreement. And then there's not a place to put them. When asked, like, where can we put them? That's an alternative. No one has an answer to that. And I think that's a failure from a county level, given all the resources that we have, that we cannot come up with, with places and options for young people who find themselves in those situations.
Okay, yes, I agree with Shalon. And I think, as was stated prior, I mean, there are certain offenses that were kind of mandated to detain in IDC. But I do think that our IDC officers here really kind of go ahead and take into consideration the elements of the offenses, and also the history of the youth. In that interview in which if the prior to detention, if the youth was well behaved, was going to school, I think all those elements are taken into account in order to consider maybe instead of detention, the youth being cited out, maybe being placed on home arrest. But I think, like Shalon said, we are kind of limited to the options we have currently for services for these youth. Other than those two options that currently IDC utilizes, I'm going to say that probably the most.
I'm just going to add one thing to that. Probation cannot release the kid on certain offenses, but that does not preclude them. And this is for the attendees. I know everybody on the panel knows this, but probation can recommend less restrictive options when the youth is before the judge. So the mandate is just on the front end. If no one else wants to add to that, I was going to go over to Erin, and Erin was going to define detention for us and what are the points along the stages where there are other options to detention in the juvenile hall. Erin?
I don't know if it's possible for me to share a screen or slide. If not, then that's fine.
Erin, it's not in, but
Okay.
you can email it to me and then I can send it to Janae who can share it if that works for you.
Okay. I will do that right now while I'm starting. I think what I would start by saying is it's one thing to look at a system and decide what needs to be changed. But I think even before we do that, we have to look at the system and decide what is supposed to be happening and whether that's happening at all. And if it's not, then why don't we start by doing that? And I'm going to say I also have a brand new computer, so this is going to be its own trick. The idea that we are sort of stuck with laws or stuck unable to get certain things that we want, I think is wrong at this point. What we have are sort of a series of laws that I think the state of California put together for its own convenience and finances that we are stuck with for better or worse, but that mean things we don't understand them to mean. But it is what it means nonetheless. And one of the examples of that, and I'll just see if I eventually get the ability to share, is the options that are available at different points in the system. So if probation determines that it's going to detain a young person, they have to find that certain conditions exist, right? First. And I think too, it's important to say that even the categories of mandatory detention are not mandatory detention. They are mandatory custody until a young person sees a judge. And there is nothing in California law that says that can't be immediate. There is nothing in California law that says a petition must be filed for a child to see a judge. And in fact, in other states, they do not have that. They routinely take young people in for a detention and release hearing prior to the filing of a petition. Because if you look back at 636 and the detention hearing statute, it does not require the judge to review the charges and petitions. It's requiring a lot of other factors about the young person's life, but not the specific charges and petition. So what other states do and what California could do is file something that explains to the judge and to the young person the reasons that they were brought into custody. And I did send, I think, my slides, but maybe it's not going to go through, and that's fine. And if they do that, then all of the rest of the factors can be considered. That should happen immediately. And the way our statute is written, it says a young person should have a detention hearing as soon as possible, but in no event later than 24 hours after the filing of a petition. What we do in practice is do it within 24 hours of the filing of a petition. So that's sort of an automatic 48 hours or more in custody before this happens. I think that's far too long. I think a day in detention is too long, especially for a child who shouldn't be there at all, especially for a child who's going to be released by the judge or the DA is going to agree to release at the hearing. Why is that young person spending up to, frankly, 8 days if you get arrested the day before Thanksgiving, 8 days in a juvenile detention facility only to be released? That's insane, in my opinion. And I used to practice in New York, so I am absolutely certain you can be ready to hold a detention hearing and get a kid out on an hour's notice if it comes to it. Because the way that you deal with that is there's a second bite at the apple. Because once you bring a system so far forward, it's understood that more information will be coming in and that you can use that more information at the hearing when the petition is filed, which is going to be in 48 hours if a young person is held at that first hearing, right? So I think we have to relook at the timing and rethink what actually do we need to know and what actually can be done and what is the law forcing us to do and what are we doing for our own convenience? Because it doesn't benefit a young person to sit in a cell for extra days if that was never going to have to happen. And I'm actually surprised routinely by the number of, oh good, I'm sort of on slide 7. The number of cases where a district attorney will come in and agree to a release where a young person has sat in detention. And I bring this up in particular because New York City had, and I think Chicago and a couple of other places have weekend detentions for young people. And the last report out of New York was that 75% of the young people brought in over the weekend for detention were released by the judge. That's astounding, and it should terrify all of us, because if we are keeping that number of young people in detention on any given weekend that don't belong in there, frankly, I think that's a crime. So if we think of where there's just what probation has to do when it's even considering a detention, it has to look at whether the continuance in the home is contrary to the welfare of the child. That's the language of foster care. And that's what I mean when I say we've conflated a whole bunch of laws and put it together for our convenience and our financing. But that is not about what did the young person do. It is about their welfare in their home. And in order to detain, they have to find that it is contrary to their welfare. And they have to find specifics, be able to put together the specific circumstances that would lead up to that and make out reasonable efforts. If we switch slides, sort of where I was going, youth, when they are going to be held in custody, I think I did the first one where youth have to be held in custody, not detention, right? So if you're picked up and it's one of the 707Bs and you're brought directly to court to see a judge, you never have to go through detention, even though it was one of those cases. Youth who are detained, I think a lot of people think of detention as juvenile hall. Detention does not mean juvenile hall. Detention means removed from the home of your parent. You are detained away from the home of your parent. And one of the easiest ways to check yourself on that is to go over to the 300s and look at what happens when a young person is removed over there. They are detained. They don't go to juvenile hall, but they are detained because that term means removed from the home of your parent. And it triggers a whole bunch of things. The statute for 636 for the detention hearing allows the court to detain in the juvenile hall or any other suitable placement, which is on my next slide. It doesn't require detention in the juvenile hall. And probation is allowed to operate non-secure detention facilities. So just by that fact, it doesn't have to be in a juvenile hall. And I think we often think, well, the first time a judge is ever going to see a case in the way that we currently practice is at the detention hearing. That's false. A judge has to review the probable cause for arrest within 48 hours. And I know there's a California Supreme Court case. It is not a full opinion on it can take up to 72 hours. And so we all think we have that 72-hour window. We're blowing by it on many occasions. But even the U.S. Department of Justice has routinely held and found that the application of Gerstein and McLaughlin, which create that 48-hour probable cause review rule, apply to juvenile court. So, and a number of the circuits have held that as well. There need to be within 48 hours a review of the probable cause on that case. And if it hasn't happened, young people need to be released. If we go to the next slide. And if we look at the detention hearing requirements, the judge also is going to have to review a report that's all about risk of foster care placement, continuation in the home, and reasonable efforts. That report is required to be done by probation if they are requesting a detention. So anytime probation stands up and says, we are recommending that the youth be detained, my question would be, where is this report? And the report must include the items here. Why are they being removed from their parents' care? That's the continuance in a home is contrary to their welfare component. Any 300 involvement that young person had, do they actually have to be continued to be detained for the detention reasons in addition to the other reasons, or rather the juvenile justice reasons in addition to the others? And what services are available that might alleviate the need for this detention, even if they haven't been put into place yet? What exist, and whether there are any relatives who might be able to come forward and step in if the parent can't do it right now. That all has to be provided every single time probation requests a detention. If we go to the next slide. And before the court, they have to review that. They have to find that there's a prima facie case, which means that all of the elements of the petition or the charge, at least one charge, are met. Then they have to find that continuance in the home is contrary to the welfare, which again cannot be because of the severity of the charges, because the youth might run away, because the safety of the community. It has to be about their home environment and their welfare in that home. If they can't find that, there's no lawful basis for detention in the state of California, the way the code is currently written. They also have to find one of the following other grounds, right? That they violated an order of the court, that they've committed a new offense that would be a crime, and the other ones that we think of as juvenile justice. If we go to the next slide. And I'm going to skip a couple because I always have more slides than I have time. Always, it's a critical problem. And if the court finds that they still do not have to detain, but they can, it's written as a may, but if they do detain, they have to find one of the least, I think I'm actually, could you go one more slide? They have to find one of the least restrictive options available. So that includes a placement with a non-relative or relative, a placement in a foster family agency assigned home, a placement in an STRTP, which is the now group homes, a placement in therapeutic foster care or in one of the new therapeutic placements that are available. Those are all detentions under 636. Those are not alternatives to detention. They are detentions. They are far less restrictive forms of detention, and I think we should be utilizing them wherever possible. But they also, some people are like, well, why would you want to detain with a relative versus release to a relative? Well, there's no such thing as a release to a relative, because if you've ordered a child not to return home, you've interfered with parental custody, and so you've issued a detention and removal order. Also, that order places a lot of additional services and entitlements into that family home that could be really useful for maintaining that young person in the community. So there's a lot of reasons to think of it differently as we go forward. And I'm just going to flag on my last slide, which I know we haven't been asked yet, that there are a whole host of new services and available to be utilized under the child welfare system. I think we need to push one slide there forward. And under the new Medicaid and Medicare laws, and some existing requirements under child welfare that we've just really never fully implemented on the delinquency side. And all of those could really expansively serve young people, either in less restrictive options for detention or in community-based settings. And I think a whole day could be spent just sort of going on about those, but they are really, some of them are really important to think about, because this is like the Medicaid rollout that we're having right now for young people is a first in the nation attempt at some of these community-based alternatives. I'll leave it there.
Thank you, Erin. Panelists, anyone like to make a comment or has a questions? We have about 7 minutes before we turn it over to our attendees.
Chair Mundo, just really quick, I want to let folks know that we will be creating a link to those slides, if you can just give us a moment.
Luis?
Thank you, Chair. To Ms. Palacios' point, whether we have to change something instead of just improving what we already have, it's a great question, right? And what I want to draw everybody's attention is that something that Mr. Rodstrom brought up during his presentation that coincides with what Ms. Palacios is saying, which is this is supposed to be a civil process, not a criminal process as it's written in the codes. But realistically, if you think about that, if it was truly a civil process, there wouldn't be incarceration in the equation, right? So I think part of the problem in the way that we think about things is that, and it's been pointed out by Ms. Palacios, kids do not have to be incarcerated, which is a different definition than detained. And unfortunately, although we call it a civil system, it truly is a criminal justice system, because if you did something wrong, there's always the potential of being incarcerated in a jail. So it's not a true civil system. So we have to accept that, and with that, we have to make changes according. I have to give credit to DA Gascon in that all of us working together. There's an attempt to change the way that we look at the system, and the system is supposed to be set up as a civil system, not a carceral system that it's turned into. So I'm just throwing that out there, Chair Mundo, in that I know all of us here are working towards changing the way it's turned into from the way it's supposed to be.
Commissioner Terry, any questions, comments?
Not now, no. Thank you.
I do have a question for the panel. And I thought about this the other day. I was assigned a new case, and does the process allow for re-evaluation of releasing a youth from detention? I mean, let's say he's been in there, or she's been in there, or they've been in there for 3 weeks, and we see significant improvement and stabilization in the family has been documented. And if there is a process, how often is that process in play?
Let me jump in quickly. Yes, we being the defenders and the prosecution and probation continually work to reassess whether the youth should be detained or not. Is there a process? The process, changes, right? It could be going into court, asking the court to reconsider. It could be structured release, which has been led by probation. It could be the TMDTs, which focus on girls and gender expansive youth. We're expanding the tools by which we can release kids from detention. But yeah, look, as defenders, we're always going to be a pain in the side to court, prosecution, and probation, because we're always looking to see, okay, we see changes. I want my kid out. So yes, and yes.
Thank you. Erin?
I wanted to clarify that I do think that the system needs radical change. When I say there's things we might improve versus change, I was thinking more of the law. I think the law gives us a lot more room right now to do things better than we do them. And I hear a lot of times people say, well, we do this because we don't have a choice, or we do this because it's the only option. And I think, well, that's the craziest thing I've ever heard, because I've read all the laws around what you're looking at, and that's not what it says. For instance, waiting 72 hours for a detention hearing, not necessary. In fact, I would argue illegal. The other thing is, when a young person does go into detention, I think arguing for their release at every available opportunity is the only thing that really makes any sense. And if we look at the way the detention statutes are structured, the court is supposed to make orders for reasonable efforts to get a young person out of detention at the detention hearing. It should be reviewing whether those have taken place, whether those have been made, whether services are now available to release the youth at the next hearing, at the hearing after that, every single time. There's also a requirement from that detention hearing starting that probation is supposed to do a family finding, which is much more expansive than people think. And that's due with diligent efforts within 30 days to be complete. So maybe they've identified a resource by the next hearing. I think if we move everything faster, what we also have to think about is at every opportunity, we're going to have learned more, and we should do better by that young person every time they're in front of us.
Eric, you indicated that one of the major differences is the trial, but what about the idea that there's no bail in juvenile? And that's something that's afforded to the adults who sometimes commit more violent offenses than the youth are charged for.
I think that's a great point. I think that's a really broken piece of the system. So, the fact that I, in that moment, didn't pick one of that or probably many other things to point out was simply me not thinking of it in the moment. But I completely agree with you.
Okay, panelists, before I move on, any last comments? Give the attendees a chance to chime in. Okay, Wendy, at this time, would you please facilitate public comment for us?
I am more than happy to. We'd love to hear your comments. Please raise your hand on the little raise your hand button. If you're calling in on the phone, dial *3. If you're on YouTube, hop over to WebEx, please, so that you can comment. We are going to start with Adrina. Adrina, welcome back. Happy to have you here. Thanks for spending your evening with us. We're going to unmute you. And you can go ahead.
Can you hear me?
We sure can.
Okay, good evening, actually. My name is Adrina. These are my comments based off everything I just heard. As far as the public defender's office and the district attorney, I hear you discuss a youth's vulnerability and potential learning disabilities, but you give them the responsibility of an adult and excommunicate the parent in speaking or representing their child while in court. I can't even ask a question. They lie in the beginning to include the parent, then come back and say, I don't have to answer to you. I'm not your attorney, I'm your child's attorney. That needs to stop. It takes advantage of our young people's vulnerability and learning disabilities. Also, the DA takes over a year to set a pretrial date, and while they can't post bail, they are sitting in jail the whole year just for their time not to count. Even the judge was questioning the DA and the length of time she was taking. We need to start counting the time the youth are incarcerated while on trial or allow them to post bail. You also need to stop holding kids accountable for the actions of others. My son is sitting in jail for a crime he did not commit and is being punished for another man's actions at the young age of 14. Knowing we have no control over the actions of others, that's a huge failure from the county and unfair treatment. It's pure evil. Now, if we're going to do this, why not apply it to the adults? Last year on July 24th, 2023, a group of officers assaulted a youth while only one was arrested and charged for it. What happened to guilty by association and accomplice like you harshly punish kids? Or is this selective policy and you place yourself above the laws? It showcases favoritism and corruption in our system. As adults, we know better, and here the adults are free and the kids get harshly punished. What kind of message does that send to a community? It showcases that if you're a police officer, the laws do not apply to you, which will cause chaos. The juvenile justice process is worse than the adults. They are violating the Youth Bill of Rights. What happens when our Youth Bill of Rights are being violated? What's the punishments that's supposed to protect our kids? We also need to interrupt the school to prison pipeline and strip the power from the corruption of the schools. They arrested my son for a possession of a firework when he was doing great. It's beyond criminalizing, and it's the biggest setup I've ever witnessed in my life. Thank you.
Thank you, Adrina.
Thank you. We'll go next to Marcos. Marcos, we're going to unmute you. If anyone else would like to give comments, please use the raise your hand function. Marcos, we can hear you. You can begin.
I'm actually from Ventura County, and I'm glad to be sitting in listening to your panel and your commissioners speak. So when it comes to a placement outside of LA County, what in regards to that are you looking for as to something that would qualify to get your youth out of the detention center and into a facility if their home's not able to accommodate, a place for them to go back to? That's my question. Just because for future reference, we're out of here in Ventura County trying to start, or we're not actually trying to, we're in the process of starting a youth development group nonprofit. And so one of my visions for the future is to actually have a live-in placement for Ventura County. But I mean, if it's something that would work out for LA County, I would want to accommodate anything that would help the youth out in LA County as well, to provide a placement for them. So my thoughts on that, I would like to get your thoughts on that.
Any panelists want to give that a shot? Luis?
Thank you. Great question. You know, something very interesting that's happened in the last, I'd say, couple of years. It's turned into an ad hoc informal group, which is Ms. Joseph, other members from the DA's office, defenders, probation, and the presiding judge, supervising judge over juvenile justice, Judge Espinosa. We've come together and we go visit locations in and outside of LA County. And like I said, it's turned into this informal working group where we look at different places. We go in there, literally sit down, talk to the folks who are running the programs, and then we have discussions with the court as to whether this is a viable option. So if there are providers outside of the county, we're definitely looking at them. And I'd ask for you to send information to Ms. Joseph, to myself, Mr. Abrahamian, and Mr. Rodstrom, and probation as well, because hey, if it's out there, we're going to go look at it. So we're invested.
Yeah, thank you for that. Yeah, it's definitely something I want to build on, and getting your input right now is going to, help us do just that. And if we can, coordinate or help build that together, that'd be amazing.
Marcos, I'm going to ask Janae to put my email in the chat for you, and I will connect you with Mr. Rodriguez and the team. I can't hear you, Shalon.
Sorry, just adding to what Mr. Rodriguez said, is that one of the placements that we did look at in Ventura County was the Conservation Corps. And the court has placed young people from LA County in the Conservation Corps in Ventura. And that was after one of the visits that we took to the site and talked to the staff there and looked at the programming. So it definitely is something that the courts in LA have considered and done. So I would encourage you to, get in touch with us so that we can continue that conversation.
Okay, we'll go next to Kay. Kay, we're going to unmute you. And you can begin.
I'm speaking.
Kay. Oh, great. Sorry. I'm sorry to speak over you. We can hear you now. Please begin.
Okay, so this is my first time actually speaking at one of these oversight meetings. I was wondering why these meetings aren't so my son is currently at LP, and I was just wondering why is it that the parents aren't informed in regards to like meetings like this? It took me a lot of researching and asking questions for me to even know about, things like this existed. And I was wondering why they don't have any type of like educational programming or any skill enrichment or any other type of programming aside from just going to school and being in their unit all day long watching TV. What are they being like? They don't even have church, and that's like a big problem. I feel like they just have a lot of time in their hands and they're not using it wisely, or they're just kind of building up tension. And instead of like, you can't even send them books, for example. For whatever reason, I feel like if they would have church or any type of like extracurriculum classes and the weekends or something, they would have something to do and not just sit around and turn the tension against each other.
I'm so happy you're here, Kay. I'm also going to ask Janae to give you my contact information. And Commissioner Mundo and Commissioner Terry, is there anything you want to share about what you all have been doing as far as reaching out to parents and going to Los Padrinos talking about programming?
So we do visit and we meet the kids and we inform them of our existence. And if they ever need anything, to contact us. I actually sit in the hallways of courtrooms and meet with families. I think that Mr. Zaragoza probably can answer a little bit more about things like church and programs that the hall does have. Mr. Zaragoza?
Yes, yes, actually, I was gonna go ahead and kind of raise my hand. And the thing is because, although I'm not here at Los Padrinos on a regular basis, I do attend the interagency meetings that they have on Wednesdays. And I am aware that they were having religious services as of, I'm gonna say this just because I heard the chaplain go ahead and talk about services last Wednesday. Uh, Mr. Christopher Watkins, who's also here, kind of give an update of all the programming occurring during the weekends. And also, I heard there was a big program on the holidays. So there is a constant program kind of going on here anytime a youth has downtime. As far as literature being brought to the kids, I know in the past, during visiting, we would go ahead and take literature for the youth. If they brought it, of course, it would have to be collected at the entrance for kind of review, and then they would provide it to the youth. So the thing is, it is something that based on the items that Ms. K brought up, I can go ahead and I'm making notes, and it is something that I will bring up tomorrow at tomorrow's interagency meeting, and we'll provide an update to the POC Commission and also anybody else that requested.
Aaron?
Since I don't work for LA County, I'm free to say it's not doing very well, as I please, which is always the reason why I know I'm never going to get a government job. The thing I think we have to be honest about is Los Padrinos and Barry J and a number of other facilities in Los Angeles don't have sufficient programming. They simply don't. They've been cited by the Board of State and Community Corrections as being unsuitable, and one of the reasons for that is a failure to provide minimum levels of programming, which is 1 hour a day most days. And I think we just have to be real about that. I don't think it's unique to Los Angeles, and I don't mean this with any disrespect to Mr. Zaragoza, whose comments I've really appreciated tonight. I think also it's probably not, I don't think it's because everybody in there is, malevolent and trying to harm young people. I do think there's a lot of people who want to do better. I don't think that's coming tomorrow. And I think we have to be honest about that. And it is one of the most important reasons for this conversation, because we need to get young people out of there whenever possible, because they are not getting what they need. And I also think it falls below the minimum constitutional level of rehabilitative services required for young people who are not criminally detained. So I do think we have a long way to go. I'm seeing it in facilities across the state. The board is citing facilities across the state. They're just not doing well enough. And I just had to say that, because the only way I know how to assess what happens for these young people is the standard which I would want for my own children, and we aren't even close.
Okay, Chair Mundo, can I go back to the next commenter?
Yes, ma'am.
Okay, we're going to go to Tanya. Tanya will unmute you. And you can begin.
Thank you very much for this meeting. And I'd like to address my comments to Aaron Palacios. Do you have any way that we can help ensure that the courts routinely meet and make sure that all of the requirements that you've cited that should be met, meaning that the kids should be assessed within 48 hours, and that there be continuous meetings to make sure that the kids are given every opportunity to get out of the system? Is there anything that we can do to make this happen? Like, do we have to meet with legislators? Is this a change in statutes that needs to take place? Do you have any ideas of where we would begin to start this process?
I don't think it requires a change in law. I do think it's a good question about what do we do. The first thing I think we do is we stop looking for places to put young people and start thinking about just what young people need. And every time we think about that, it should be based on the individual assessment of a young person. And that's not a cop-out answer. That's because that's actually where I think we start. California has developed a new systems of care model and process called the Child and Family Team. It sounds like it's just another meeting. It's not intended to be just another meeting. It's a process developed from like 30, 40 years of systems of care research in children's mental health, which places children and families at the center of the program planning, placement planning, and needs planning. And it brings in people from the young person's community. Those meetings should happen and be scheduled with the team specific to that young person, their mental health provider, maybe a teacher, their parent, their sibling, their aunt, uncle, coach, whoever is a big part of that young person's life, who has something to offer to assist that young person in positively moving forward, should be invited into that meeting to help make a plan. There's no reason that meeting can't happen faster. I understand that probation is overtaxed. I do think one of the things I'm not going to be somebody who supports a lot of funding into probation departments, but one thing I would support is funding for probation departments to hire social workers. Because I do think that one of the first things that needs to happen for a family, even if it can't happen by the detention hearing, then immediately thereafter is somebody who is qualified to do that kind of assessment and that kind of planning, to sit down with the entire world that surrounds that child and help develop a plan. From there, do we need some additional resources? Yes, I do. But I think if we were to shift how we think about what we're doing for young people to meeting their needs and helping them to recover from what is clearly a trauma that has led them there, because kids are not born saying, you know what, I'm going to go commit a massively horrible, heinous crime. There's something that has happened that needs to be addressed. And there are services that exist to help address it, but we have to shift the focus to that. That's not an easy solution. It is going to require some kind of investment in people who are trained to do that kind of work. But I think we could bring that. So I think San Francisco uses social workers in the probation department. I can't remember, maybe Santa Clara does as well, but I think that's something that should be considered immediately and be built as a program, because I think it would save us a ton of money, because every time we put a young person in detention, we spend a lot more.
Okay, we'll go next to Jessica G. Jessica, we're going to unmute you. You can begin.
Jessica Gonzalez. I am the Youth Justice Program Manager with CASA of Los Angeles. So I'm so glad I came in right after Erin made her statement about the CFTs. In the last year, we've launched what's called our pretrial advocacy program through CASA LA. It's staff who are meeting with young people in juvenile hall who have been there for over 30 days pre-adjudication. We're doing basically what are needs assessments. What are the needs of the family? What would the child benefit from in the community, right? Because they don't need to be detained. A lot of them have trauma from very young. A lot of them are former dependents. A lot of them are parents of dependency. And the resources exist to help them in their own communities and not in these facilities. And so at CASA, what we're doing is really training our advocates that work with young people who are already in the community to be the ones to change the narrative for these young people. So very intentionally disrupting, calling them delinquents, calling them criminals, calling them dangerous, which I think is dangerous in and of itself. And so but the barrier to that has been probation, and probation allowing us to come into juvenile hall, to talk to young people in their units, to figure out what the needs are, to figure out how we can get in contact with the courts on their behalf to advocate for them. But our programs exist. We're here to help. So the parents that are on the call, our office is located on the first floor of Edelman's Children's Court, or we're in the courthouses pretty often. Look for our badges, CASA LA. Thank you.
I'll just put in a little plug for parents meeting with CASA, because they're also very familiar with the child welfare processes and protocols, which overlap here. And a lot of what I'm talking about are from there. And we forget in the delinquency system that because of the way we've wrapped in child welfare, parents are technically entitled to ask for an attorney, because they're entitled to reunification services and due process to try to get their child back. So if they're not getting any services to try to improve the conditions of their home or improve their ability to supervise the young person or meet that young person's mental health needs, then we aren't meeting our due process obligation to that parent, because that's one of the services that's required to be provided.
Absolutely. And I think one of the barriers to that.
Oh, sorry. We Jessica, I think
Here I am.
you're unmuted again.
Yeah, so one of the barriers that we've seen with that, right, is parents not understanding the process, not understanding their rights. So we kind of sit there and we also kind of translate, right, all of the legal language that's happening in the courtroom so that they understand what the next steps are. Also, one of the things we're seeing is there's young people detained in juvenile hall with no parent figure, and DCFS then drops the ball on them. So now, if we do release them, where do they go? DCFS refuses to file on them or refuses to take custody because at the time of the referral, they were in a probation facility. So that's also one of the barriers that our young people are facing, is then they're being released and they don't have anywhere to go. They don't have a parent that's available.
Thank you, Jessica. I'm going to call on Vivian Wong next, but there was a call-in user who had raised their hand, and I think you maybe hit *3 again, and we lost you. So if the call-in user who wanted to speak can hit *3 again, we'll call on you after Vivian, but we'll unmute you, Vivian, and welcome. There you go.
Ian Wong. I'm an education attorney with the Youth Justice Education Clinic at Loyola Law School, also a member of the Education Justice Coalition. Thank you so much for holding this virtual town hall on breaking the school to prison pipeline. I think, of course, it's really hard to talk about this without bringing up education, right, and how deficient it is in these juvenile detention facilities. And I think that, Aaron, thank you so much for your participation in this panel. And for highlighting that the average time in these facilities for a young person, at least in juvenile hall, is about 8 days or 10 days. But, I represent clients who've been there for months at a time, and in and out for years. And so these young people who are in these detention facilities are necessarily taken away from their community schools and then enrolled in these LACO schools that actually don't even have A through G requirements. These are required courses that you would need to apply for a UC or CSU. And so any time spent in these juvenile detention facilities automatically puts you behind your peers in applying for these, competitive schools. Mm-hmm. And not to mention that we don't even give them the college prep necessary courses to help them get ready for that type of education, higher education. And so I just wanted to emphasize that, detention is extremely harmful to young people. With these deficient conditions, you really can't learn in a cell. Thank you.
Thank you, Vivian. And did you want to comment on that, Commissioner Mundo?
No.
Okay. Ismail, it's call-in user number 7, whose number starts with 626. If you can unmute, and I think you have to dial *6 to unmute yourself. I'm sure Janae will correct me if I'm making things up about WebEx, but I think it's *6. There we go.
Good evening. My name is Jessica Garcia. My first time joining something like this, trying to get more familiar with the youth advocacy. I currently have a son who's 15 years old, already in the system, and is not a gang member, but probation is deciding to put my son on gang file. And it's kind of concerning and disturbing because I know what comes with it. And mind you, he's 15 years old. My daughter gets out of school. This happened on Thursday. Abuse of power. My son was already searched. He did not run. He wasn't being detained, but he was cooperative with the police officer of the city of El Monte. And yet my daughter's making sure her brother gets set free, right? Because similar to the first speaker and other speakers that I've heard, he is being stereotyped. And when they say product of the environment, it's scary because, again, they've shared learned behavior or things that they're already born into, like of dependency and all these other terms that I am going to get familiar with and I am going to do my homework. But it's really disturbing when I do feel powerless. And I have also heard that term where, I'm his lawyer, I work for him. But I don't know legal terms. My son, let alone, does not know any legal terms. So for him to be, I feel like it's a spider web set up for him where he he talks to me. He's part of a great program. I feel like they can have better people who better identify with him. So currently that's what we're doing. It's called, I can't even think about it. I have it at the tip of my tongue and it's just not coming to me. But it's concerning where my 14-year-old daughter is recording her brother, knowing he hasn't committed a crime and just stereotyped for being at a park, which is across the street from the school. And she's recording, and unfortunately, no, she's not a video photographer or anything. So it is kind of choppy, but other people are aware and watching, and the police officer kicks the phone out of his hands using unnecessary force when he's compliant, when he's standing and then asked to be sitting. And it's one of those cases where I don't want that to be where if he makes the wrong move, is that going to have him body slammed on the floor, being
Thank
a
you.
minor?
We're about ready to run out of time. So we're just going to take, if we have any more listeners, and then wrap it up.
There's no one else signed up. I just want to say thank you, Jessica, and also to Kay and Adrina, who regularly comments. But Jessica and Kay, thank you for joining the meeting today. We are actively recruiting parents to participate more in our meetings, and we encourage you to reach out to us so that we can help you understand those terms. We have staff member Belinda Mellado, whose job it is to connect with the community members and parents. And I would love to volunteer her and myself to speak to you to help you understand the terms and invite you to our future meetings. Go ahead, Commissioner Terry.
Just quickly, because I know we're wrapping up, but 2 callers now have kind of mentioned the relationship with the public defenders and how that can be a barrier, and especially if you're trying to understand, what's happening. Just wondering, is there anyone who could speak to that or address that? And because I think that's we're seeing some critical points where families could be engaged, or maybe they're, but if you're seen as adversarial, I don't know if anyone could speak to that in response to those callers, as well as the delays sometimes in hearings that Adrina had mentioned.
Let me take that. I'll take the second one first. Look, every case varies, and not every single case is the same. So there's various factors that affect why a case is being delayed, whether it's preparation for trial or working out a disposition. So there's no easy answer to that. As to the first question, as to why attorneys will sometimes not want to communicate with the parent, let me make this very clear. There's ethical obligations between the attorney and the client being the youth, that certain information cannot be shared. It just cannot be shared, because if it's shared with someone who doesn't hold that privilege, then that person becomes a witness and can be called to testify against the youth. And as attorneys, we have a license and we're regulated in that we're supposed to behave in a certain way. And there's certain privileges and communications that cannot be shared with anybody outside of the defense team, period. Now, as to how that information is communicated and how that is, what is commonly known bedside manners, there's definitely a lot of room for improvement. And I, as a supervisor in the public defender's office, I can tell you, I welcome those situations and have a discussion with a parent or a guardian when they feel that they're not being listened to. And sometimes, look, not everybody has the best bedside manners, but the reality is we have an ethical obligation. We must preserve that, but there's certain ways of communicating that to the parent or guardian or somebody who's interested that can be improved on. So.
Thank you.
Can I plug for parents? Because I practiced before I was a parent, and I have to say now, even knowing my ethical obligations and that I represent young people and not parents, which I've done, I can't imagine somebody telling me that they're going to speak to my child without me about things that are going to have such a radical impact on their life. Like, that's emotionally, that would not work for me. So I get that when I hear parents say it. I don't think it changes the reality that those things have to be kept confidential, but it is a good reason that for a parent who's really struggling to understand, for maybe a defender to suggest to the court that they need to be assigned counsel, which they are able to get under the code. And it says it right there in the middle of the code. And the other thing is participatory defense programs do a really good job of working with families to make sure they're understanding the whole process, and often have relationships with the defenders that will help bridge that gap. So I would look for both of those.
Thank you. Wendy, no more callers?
No, thank you so much for everyone who spoke up today.
Okay, well, our time has come to an end. Thank you all so much for joining us. Our next virtual town hall is Wednesday, April 17th at 6:30. Our next commission meeting is on Thursday, April 25th at St. Anne's Events and Conference Center at 9 a.m. You can find registration details on the PLC website at plc.lacounty.gov/meetings. Thank you, everyone, for listening and for participating, and have a wonderful night.
Thank you.
Thank you.
Thank you.
Thank you.